excellent presentations. But sometimes maybe there's a key thought, one nugget you'd like our attendees to walk away with, and something that you really want to drill home for them to keep in mind as they go through these materials later. And I want to turn to each of you now for those remarks. Matthew, we'll start with you since you began.
Thank you. I would have two high-level key takeaways. The first is that on a very broad level, the effect of the merit management decision has made it more difficult for parties to be sure that their transactions are protected by the safe harbor. When you could use intermediaries to satisfy the safe harbor requirements, it was a much cleaner way to analyze transactions. So now the importance of having counsel carefully examine transactions to see how they're structured is only enhanced. And secondly, I'll just say that bankruptcy trustees are always looking for ways to bring lawsuits and to get around the safe harbors. So defendants need to be just as careful and aggressive in making sure that their rights are protected.
Excellent. Thank you so much. Mark?
Thank you, Elizabeth, and thank you, Matt. Just a few kind of thoughts. The Supreme Court's decision in merit management halted what I thought was the continuing expansion of the scope of Section 546E. It did not, however, I think, restrict the application of Section 546E to the purpose expressed in the legislative history, which Matt alluded to, basically to protect securities markets. As a result, rather than providing more guidance, litigation over the application of 546E will continue. And with regard to litigation, in the near term, forum selection and pleading will have an enhanced role in the application of Section 546E. And as Matt suggested, with regard to structuring transactions, I think the Second Circuit's Tribune decision provides guidance on how to structure a transaction in order to fall within the safe harbor of Section 546E.